So let's talk about liquidated damages and remedies. The earnest money deposit is often the liquidated damages in the contract. And our contracts have a provision for liquidating damages to a seller in case a buyer breaches and doesn't close. Our contracts do not require mediation before you litigate or proceed with resolving the dispute over liquidated damages. Our contracts do include an arbitration provision in addition to the liquidated damages provision. By the way, as most of you know, both of those have to be separately initialed for them to be applicable. The arbitration, however, only applies to the disposition of the earnest money deposit. In other words, does the buyer get it or does the seller get the earnest money deposit? If you're a fan of arbitration, you can broaden the application of the arbitration provision to apply to all or more disputes. From the seller's perspective, it's not uncommon for a seller to establish a deductible for buyer's damages for seller's breach of its warranty before the seller becomes responsible. In other words, if there's a breach of the seller's warranties, the buyer has to suffer at least, for example, $50,000 worth of damages before the buyer can proceed against the seller for breach of seller's warranties. That's common. That's very commonplace. Conversely, the seller can also put a cap on the seller's liability for breach of warranty. The argument typically goes that like this: well, the buyer has put in usually a 3% of the purchase price as earnest money deposit, and the contract has a liquidated damages provision, and it provides that if the buyer breaches the contract, then the seller can get the liquidated damages, and that's the extent of the buyer's exposure for breaching the contract and not closing. So the seller's argument is that I should be able to put a similar cap on my liability for my breach of the contract. This is a breach of the warranties, not a failure to convey title. And this will range, depending on the property type and the leverage and the price, it will range from a low of 1 or 2, 3% to 5, 10%. But the cap on the seller's liability is an important provision to protect the seller in case there are extensive warranties. Another protection for the seller is to have the buyer waive the right of specific performance or add reciprocal liquidated damages for seller's breach. Now, buyers seldom agree to this because this allows the seller to sell the property from under the buyer. And if a buyer enters into a contract to buy a property, they're intent on buying that specific property. And I've not seen too many buyers who are willing to agree to either the waiver of the specific performance or reciprocal liquidated damages for breach.